Good morning with everyone. Thank you for being here today. Today we have a very interesting and specific class for those of you who work with international clients. And we have with us Stephen Gurian from 1031 affiliated, 1031 Exchange affiliated. He will be giving us a lot of information about how to buy and sell with international clients. So please welcome Stephen with us. I see someone here in the chat that's saying that it's very difficult to. Good morning. It's very difficult to understand. Who is this, Carolina? If you don't, I don't understand what you mean by that. Is the sound not enough? Okay, everybody else is hearing okay. Please let us know. Carolina, it might be your computer. Johanna is saying that she hears fine. Yeah, so maybe try to see if Carolina, if yours is not working properly. Okay. Thank you, Stephen, again so much for being with us. I know that this is a 2-hour class, but you're going to try to just give us the highlights.
Yeah, of course.
In this Zoom, and then the idea is to welcome the team to a presentation in your office, which will allow us to get the continuing education credits. So thank you again so much for being with us today.
Yeah, of course, anytime. Do you want me to start, or are you gonna wait to let anybody else in?
Yes. Let's start because I know the time is of the essence, and we try to start our classes on time, but just let's just continue as if more people start joining in.
Okay, you got it. All right, so good morning, everyone. My name is Stephen Gurian. Let me share the slide. So today we're going to be talking about, so a little bit about me. So I'm an attorney. I've been practicing law for 13 years. And then I primarily deal with taxation and trust and estates, probate, things like that. All the exciting stuff that people go to law school for. So that's what I do day in and day out. Um, I have an element in taxation, which means I spent another year in law school studying only tax law. So I'm technically an expert in my field. And it also means that I spent another 50 grand at the University of Miami to get that designation. So today we're going to talk a little bit about how to structure purchases and sales when we have international clients. So we're going to talk a little bit about FIRPTA. We're going to talk a little bit about what structures you should use so that you avoid, certain taxes that apply to foreigners. Um, I imagine everyone here, you guys are all in South Florida, right? So I imagine you guys have all dealt with FIRPTA and foreign buyers and sellers. So there are certain taxes that apply to them that don't apply to us. And we're going to talk about how to avoid some of these taxes, especially on the sales side, because most of the time they apply when you're selling or if they pass away. So if we structure them ahead of time when they buy, we'll be able to avoid a lot of these pitfalls that we see. So you guys all see the screen, right? Yeah. Okay.
Yes.
So, like I said, we're going to talk a little bit about FIRPTA. We're going to talk about how to structure the purchase, also how to structure the sale. We're going to talk about what entities can and should be used when we're dealing with a non-resident alien. And we're going to talk a little bit about like what tax considerations you should have in the back of your mind when we represent these foreign clients. So when we're planning for the international client, we're thinking about um, the perspective of whether or not they're looking to stay here in the U.S. as potentially become a U.S. citizen, or if they're just passive investors, if they're looking to just buy and sell property, but not necessarily be a resident or a U.S. citizen, during their time that they're here. And we need to think about, especially when we're dealing with real estate, we have to think about the citizenship not only of the buyer and the seller, but also of their spouse and their kids, because a lot of that kind of comes into play. So The big thing when we're dealing with international clients is citizenship, residency, and domicile. So these three words, I'm sure you guys probably are thinking, yeah, they probably mean the same thing, but the reality is they're completely different for tax purposes. So when we're talking about residency, we're talking about people that are actually physically here, either on some sort of visa, maybe they have a green card, or they're citizens of the United States. When we're talking about citizenship, we're only talking about those US individuals that are in fact US citizens. So it doesn't matter if they reside elsewhere. Maybe they took a job where, they got to spend a couple of years in the UK or something for some sort of project. So even though they're no longer residents of the United States for that period of time, they're still citizens of the United States and they're still paying US taxes. And then finally is domicile. So domicile has not really anything to do with citizenship. It's more residency, but it's where your intent is to remain. And the reason I bring up domicile is because that is where estate tax kind of comes into play. And we'll talk about estate tax in a little bit, but essentially if you're a foreigner that passes away with more than $60,000 of assets in the United States, then you have to pay the so-called estate tax. A lot of people call it the death tax, and it's 40% of anything in excess of $60,000 if you are a non-resident alien. But if you are, let's say you're not a US citizen, uh, but you're a domiciliary. In other words, let's say you're here on some sort of visa or a green card, but it was your intent. You decided, you know what, I want to stay here in the United States. Even if you don't have citizenship, because your domicile is here in the United States, that estate tax wouldn't apply to that person, even though they're not US citizens. So a resident decedent, so someone that passed away, is someone who at the time of death had their domicile in the United States. And then estate tax liability, like I was saying, is determined by the domicile, which is the place where that resident lives with no intention of leaving. And then for income tax liability, it's determined on residency status. So it doesn't matter whether you're a US citizen or not. If you are here at least 6 months out of the year and you're making money from some sort of US trade or business, you're going to be considered an income tax resident. Um, so now that we have kind of that stuff out of the way, how do we determine residency and domicile and all that? So with residency, we have two tests. We have something called the green card test, which just means, are you a lawful permanent resident? Have you applied for your green card and actually obtained your green card? So if the answer is yes, then you are a lawful permanent resident here in the United States and you are subject to income tax laws just like any US citizen would be. So even though you're not a US citizen, for income tax purposes, you are. Now, what if you don't have a green card? Let's say you're here like on an EB-5 visa. Well, then we look at the substantial presence test, and this one's kind of funky. But basically, a non-resident passes this so-called substantial presence test if they were physically present in the United States at least 31 days in the year for which a tax return is being filed. So in other words, the current year, you have to be here at least 31 days. And the total number of days actually present in the United States meets or exceeds 183 days. But there's special math there. So the IRS allows you to look back 3 years to calculate whether or not you are uh, a U.S. resident for income tax purposes. And the way it works is if you look at the current year, so let's say we're trying to figure out whether or not FERPTA applies to a transaction. And we're selling the property now in 2025. Well, we have to at least be here in the US 31 days in 2025. So let's say we check off that box. Well, we still have to get to 183 days, but we're allowed to go back 3 years in time to determine whether or not we meet that 183 days. And the way the math works is as follows. So for the current year, so for 2025, you get day for day the amount of credit that you are present in the United States. So if I'm here 3 months, 90 days in 2025, I get 90 days worth of credit towards that 183. Now, if I've only been here 90 days, then I'm gonna have to look back to 2024, but in 2024, you only get 1/3 credit for the amount of time that you're actually in the United States. So if I'm here 90 days in 2024, well, really, I only get 30 days worth of credit. for the amount of time that I was here. And then if we have to look back a third year, so in 2023, you only get 1/6 the amount of credit um, for the amount of time that you're here. So again, if you're there 90 days, then 1/6 of that is 15 days. So as long as you make 183 days through that 3-year look back period, whether or not you have a green card or not, whether or not you're a US citizen, you are considered a US taxpayer for income tax purposes. So what's the magic number? 121 days. So if you're in the United States at least 121 days in the previous 3 years, you're going to get to that 183-day benchmark for determining whether or not you're a U.S. resident for income tax purposes. Or honestly, for us, what we care about is whether or not FERPTA applies. So even if you're here on a visa and you don't have that green card, as long as you're here 183 days or 121 in the last 3 years, you don't have to worry about remitting FERPTA. And FERPTA has kind of become a little bit of an issue lately. So part of the big beautiful bill was that beginning October 1st, any foreign person that's selling property has to submit that payment, that FERPTA payment of 15% to the IRS electronically. And the only way you could do that is if you have an ITIN number. And most foreigners don't have ITIN numbers. Um, Usually they send the money. Basically, they're sending a check to the IRS with no number on it, and then they'll apply for an ITIN number after. So those days are over. So now you have to have an ITIN number before you sell. So if you guys have foreign clients, make sure they get those tax ID numbers. That way, when they're selling, they're not behind the 8 ball. Because if you don't send that payment within 20 days of the date of sale, then the IRS is going to charge interest and penalties for not receiving the FERPTA payment. Talked about this a little bit. So let's talk a little bit about estate tax. Um, so typically estate tax applies to everybody, right? Whether a US citizen or not. But if you're a US citizen, you're allowed to have, or I should say the IRS gives you the privilege of owning up to essentially $14 million of assets and not having to worry about that 40% estate tax. But as I mentioned a little bit earlier, if you're a non-resident alien and a non-US domiciliary, you only get $60,000 of credit towards the tax. So, every non-resident, that's buying, condos in Brickell or, Coral Gables or whatever the case may be, they're going to be subject to estate tax. So 40% of anything over $60,000 has to go to to the IRS if they pass away. So that includes real estate. It includes, tangible personal property. So, stocks in a corporation, membership interest in an LLC, um, things of that nature. So why does any of this matter? So the point is that we can structure these purchases so that we could eliminate FERPTA and we could eliminate the estate tax for these non-residents, especially if they're not planning on becoming U.S. citizens or U.S. domiciliaries. We could eliminate both of those taxes. So typically these foreign clients benefit from an offshore company. So the structure basically looks like this. This is a very simple structure that most foreigners should use when they're buying real estate. So the idea is that we have the real estate down below and it's owned by a Florida LLC that's taxed as a corporation. And then that corporation is owned by an offshore entity. It could be BVI, it could be Nevis, it could be Cook Islands, Panama, wherever there is a country that doesn't have a state tax, or maybe they have a very low income tax, in order to complete the structure. And then the owner of this offshore entity is the foreign individual. So why is it that this structure works? Well, most people, what they do is the foreign individual will own the real estate directly. And if they do that, that's a mistake. Why? Because if they sell, they have to remit FERPTA. And that's 15% of the gross sales price. So whatever's on that FAR bar contract, I'm sure you guys all use the as is, 15% of that, boom, automatically goes to the IRS. And there's no deductions for commissions or closing costs or any of that stuff. It's 15% of whatever's on the FAR bar.
Wow.
And then what happens if I'm sorry, do you have a question? Guess not. Okay. And then so what happens if they pass away owning the real estate directly? Well, that's where the estate tax kicks in. So if this is $1 million property, they're basically going to be paying $40,000 to the IRS. Because that's the, I'm sorry, if we have $400,000 to the IRS, because that's 40% of $1 million. You get the credit for the 60,000, but when we're talking about, millions of dollars, that's pretty inconsequential. So how do we avoid this structure? So how is it that this works? Well, let's look at FERPTA first. The owner of the real estate is a Florida LLC, so it's a domestic entity. So FERPTA doesn't apply in that situation, even though we have a foreign owner of the LLC, because we have a Florida C corp owning the real estate. We never have to worry about FERPTA. Now, how is it that the estate tax doesn't apply? Well, same thing. Neither this offshore entity or the foreign person owned the real estate directly. Because the individual owns this, the LLC through an offshore entity, if he dies, the estate tax doesn't apply because he doesn't own anything in the US. He doesn't directly own the Florida LLC or the real estate directly. He owns it through this holding company that's offshore where there's no estate tax. So if this person sells or passes away, doesn't have to pay FERPTA and doesn't have to pay the 40% estate tax. So this is a must. This structure is a must when you have foreign clients that are looking to purchase real estate here in the U.S.
Steven, let me ask you something. So
Sure.
that situation would also apply to investors who are U.S. citizens if they don't want to pay, like if something happens or someone dies and holds a portfolio, having an offshore owning the LLC will be the same scenario, or that would not apply?
So this structure doesn't help U.S. citizens. So as U.S.
Okay,
citizens, we're taxed on our worldwide
trust.
income. So whether we own property here or, let's say we have a little villa in Tuscany or, Barcelona or something, doesn't matter. We pay taxes on our worldwide income. And if we pass away, same thing. So this only helps the foreign individuals.
Got it.
So yeah, this, like I said, this structure is a must if you have foreign clients looking to buy or sell real estate in the US. It's not cheap. Like it costs about like 7,500 bucks to form both entities and to register both entities for the year. But I'd rather pay 7,500 than $400,000 to the IRS. Um, and a lot of the expenses associated with this are tax deductible. So it's worth it. I mean, it's not cheap, but in the long run, you're gonna wind up saving a lot of money. This structure is a little bit more complex. I'm not going to go through it, but basically it's kind of what I just showed you on steroids. And it gives you a little bit more protection. So let's talk a little bit about gift tax real quick. So gifts of real estate trigger FERPTA. A lot of people don't think it does, but it does. So if you're a foreign individual and maybe you want to try to avoid probate, you own property here and you're sick and you just don't want to deal with it, you quit claim the property to someone. Technically, that triggers FERPTA, and you're supposed to do a remission of the 15% of the fair market value in that instance of the property. So gifts of real estate do in fact trigger U.S. gift tax and FERPTA. You can't even make a gift to your spouse or your kids. You still have to worry about FERPTA. So essentially, FERPTA again only applies when you have a foreign person that is selling a piece of U.S. real estate. So unless an exception applies, the purchaser has to withhold 15% of the contract sales price if the seller is a foreign person. So it's kind of funky. Um, the the tax is technically on the foreign person, but the one that's responsible with paying the tax is actually the person that's buying. And why is that? So when we think of a closing, seller brings title, buyer brings in the money. So because the money is coming from the buyer, the IRS imposes the obligation to withhold on the buyer. So the buyer gives the money to the escrow agent. The escrow agent is supposed to set aside the 15%, send it to the IRS in 20 days, and then it's up upon the seller to file a tax return so that they could potentially get a refund if a refund is due, or pay additional tax if there was a substantial gain on the property. So even though the tax is a tax on the seller, the responsibility lies on the buyer. So there's a couple of exceptions to FERPTA. So the first one's the non-foreign affidavit. It's the most common one. I'm sure you guys have seen it if you've sat in your client's closings, or if you guys have bought property and you're U.S. citizens, you've signed one as well. The next one is a qualifying statement, which is basically says the transaction is exempt from FERPTA. Maybe you're selling the property at a loss, or you're doing a 1031 exchange. So FERPTA wouldn't apply in that situation. And then the last one that used to be really popular, but not so much anymore, is if the property you're selling is going to be the homestead or the primary residence of the buyer, but the sales price doesn't exceed $300,000. Good luck finding anything under 300,000 in Miami these days. Maybe like a condo in Kendall, like a 1-1, in the hammocks or something. But um, yeah, that exception used to be very, very popular, but
Right.
not so much anymore. So the non-foreign affidavit is the most commonly used exception to FERPTA. Like I said, I'm sure you guys have probably seen it. All it says is that the person that's selling, so the transferor, is not a foreign person. You need to provide a social security number or an ITIN number. Again, that's why it's so important to have ITINs if you have foreign clients. And you have to provide the seller's home address, and it has to be a US address. If it's a foreign address, then you're out of luck. It's not going to work. And this is basically what it looks like. It's a one pager. Basically, again, you're signing under penalties of perjury that you are not a U.S. I'm sorry, that you are a U.S. resident for income tax purposes. You're providing your social or ITIN, and you're providing a U.S. home address. The next one is the qualifying statement. Um, this one used to be pretty popular too prior to COVID, and even a little bit after COVID. But with the layoffs, I think it was like 21,000 agents have been laid off since January, and then we have the government shutdown. So these are going to be pretty impossible to get. But probably the best example is if you're selling a property at a loss. So you bought it for 100,000 and you're selling for 90,000. You're selling at a loss, and the whole point of FERPTA is to prepay a capital gains tax. But if you're selling at a loss, then there's no tax to pay, right? So why should I give the IRS an interest-free loan? So that's where this qualifying statement comes into play. So you're telling the IRS that you're saying, hey, look, IRS, um, I don't want to remit if I don't owe you guys any tax. So send me a sheet of paper that says, and it's literally a one-page paper that they'll send you, that says that that FERPTA doesn't apply to this transaction. And in the good old days, they used to do it right away. But now it takes a really long time. These days, it takes about 2 years to get these requests in. So obviously, no one's going to wait around that long. You're going to blow your closing deadline. So these have become far less popular. And again, part of the reason why it takes so long is that most clients don't have ITIN numbers. So
Right.
the only way you could like make these requests is if you have an ITIN number. Because think about it. Um, we are a 9-digit number to the government, right? We don't have names, we have social security numbers or ITIN. So that's how the government identifies us. So if we don't have a number and we're asking the IRS to do something, they're gonna say, well, that's all well and good, but who are you? Like you don't exist in in our system. So that's why it's very important to have ITIN numbers ready to go when you're going to sell, because that, believe it or not, would speed up the process significantly. Um, by having that ITIN ready, I mean, it would definitely take less than 2 years, but you may be able to get it done like in 6 months or so. Again, I'm talking pre lockdown. Now, nothing's gonna get done, and there's going to be such a backlog from when the government does eventually reopen, that these things are going to be almost impossible to get. So again, super important. If there's one thing you guys take away from the class today, is if you guys have foreign clients that are looking to sell, or even if they're looking to buy, make sure they get those ITIN numbers, because they're going to be at a huge advantage when they sell later on. Let's talk a little bit about the qualifying personal residence exception of RUPTA. So like I said, purchase price can't exceed $300,000. The property has to be the primary residence of the buyer, and the buyer has to be an individual. It can't be an entity. So no LLCs, no C corps, no S corps, no partnerships, none of that. You have to have a flesh and blood human being on title. There's a little tweak to this rule too, though. So let's say you're a single parent, and you're looking to buy the property, right? And you have two minor kids. Obviously, they can't be on title if they're under the age of 18. So the IRS allows at least members of your family to reside at the property as their homestead. So even if the person that's on title isn't there at least 6 months out of the year, um, if a member of their family is there at least 6 months out of the year, then this exception still applies, even if they're not entitled to the property. So it just has to be your homestead at least 50% of the time for the 2 years following the purchase. You sign an affidavit very similar to the non-foreign affidavit. You're just basically saying that, like, I buyer, John Smith buyer, am gonna live in the property at least 50% of the time for the 2 years after. And if for whatever reason it doesn't become or it's no longer my homestead, I'm going to inform the closing agent. The reality is a lot of this stuff just sits in the closing agent's file for years until they eventually send it to storage. So, like I was mentioning before, $300,000 doesn't buy you a lot in Miami. So there's another little tweak to this rule. So if the property has a value between 300,000 and $1 million, then withholding is 10% instead of 15. So the IRS gives you a little bit of a break there. But the same rules apply. The buyer has to be an individual, and either them or a member of their family have to reside at the property at least 50% of the time for the 2 years following the purchase. I already talked about gifts. So trusts are a little bit complicated. Basically, the only thing I want to talk about here is that if you have a foreign trust that owns real estate, it's going to be subject to FIRPTA. Um, there's a couple of rules involved when you're dealing with trust. Basically, your trustee, in order to be considered a U.S. trust, both your trustee and the laws that apply to the trust have to be, United States, have to come from the U.S. So if I create a trust and the laws of Florida apply, and then my client is a U.S. citizen, we're considered a U.S. trust for income tax purposes. But let's say I create a trust, Florida law applies, but my client, that's the trustee, is Colombian. Well, then it's considered a foreign trust, even though Florida law applies to the trust. So both the trustee and the law that applies to the trust have to be U.S. based in order to be considered a U.S. Trust. If you fail one of those things, or you don't meet one of those requirements, then you're considered a foreign trust. So like let's say I create a trust for myself. I'm a U.S. citizen, but the laws that apply to the trust are from the British Virgin Islands. It's considered a foreign trust for income tax purposes, even though I am a U.S. citizen. So if I created that trust and I sold property here, even though I'm a U.S. citizen, I have to pay for it. So very important that both the law that applies to the trust and the trustee are U.S. persons. Real quickly, let's talk about the liability on the closing agent when it comes um, to FERPTA. So like I was saying before, even though with FERPTA, the tax applies to the seller, the one that's in charge of, paying that tax is the buyer and the closing agent. So the closing agent is someone that acts on behalf of the buyer. So if for whatever reason the seller provides, false information on the non-foreign affidavit, the closing agent has to notify the IRS and has to notify the buyer. If they don't, then the closing agent or the escrow agent is going to be responsible for withholding the tax, and they have to pay penalties and interest to the IRS if something goes wrong. Because like I said, the buyer is the one that has the duty to withhold the tax. So both buyer and closing agent could potentially pay penalties and interest if they don't withhold properly. And like I said, now with that change in the law that everything has to be made electronically, it's going to make things very, very difficult. And it sort of makes sense while they're putting, you know, everyone else on the hook, right? Like typically the foreign sellers, they're leaving the country, you're never going to hear from them again. So good luck collecting the 15% for up to on those guys, right? So they're going to look to the buyer, they're going to look to the closing agent. So if you're not sure who you're dealing with, you know, what the residency status is of your clients, you know, ask them if they have a green card or ask them what type of visa they have. Because if they meet the green card test or the substantial presence test, then we could avoid a lot of this, and it might not necessarily be necessary to create that structure that we were talking about. So, you know, worst case scenario, ask a CPA, ask an attorney. Um, you know, because people like us are pretty well equipped to handle, you know, these types of transactions. Um, and then just a quick little disclaimer, as real estate licensees, you know, don't engage in the unlicensed practice of law. So the world is in suits. Don't be Harvey Specter. Don't give legal advice. Because the clients, yeah, you know, they're the ones that feed us, you know, they give us our paycheck. So they could be your best friends or they could be, you know, your worst enemy, right? Because they're going to hold you to everything that you say. Because most of the time, you know, the realtors are their first line of communication with the clients, and a lot of times they're the go-between with the attorneys handling the transaction or the closing agent. So they always look to you guys for advice. So you know, don't give legal advice. Spot the issues. That's fine. Say, hey, look, I think you may have a FERPTA issue, or hey, I think you should probably set up an offshore structure to avoid some taxes that might apply to you. But always, you know, speak to the attorney. Point them my direction or any CPAs or attorneys' direction, so we could set up the structure to avoid a lot of these pitfalls. So always consult with an attorney. Always consult with the CPA, and don't be Harvey Specter out there. You know, don't give legal advice. So my information is there. You can always email me. That's my direct line. If you guys ever have any questions about anything, you know, don't feel, you know, no tengas pena. You know, you can call me anytime you want, or send me an email at any time you guys want. I know that was a lot of information, but I didn't want to spend too much time on it. Does anyone have any questions about what we had talked about? Or does anyone want me to go back?
Yes, Steven. Carolina, how are you? I
Good.
just have one question. About the trust.
Okay.
Even if the property has a mortgage, could it be on a trust or it has to be paid in full?
So I'm going to give you the real world answer, and then I'm going to give you the lawyer answer.
Okay.
So the real world answer is, as long as you're paying your property taxes, you're paying your insurance, you're paying your mortgage, you could transfer the property into the trust.
Okay.
Now the lawyer answer. So most mortgages have something called a due on sale clause. So you're not allowed to change the title. Um, so you would need permission from the bank in order to transfer title to your trust.
Okay.
But some mortgages allow you to do that. It's already in the mortgage. So if you're transferring the property and you own the property and you're the one that has the responsibility to pay the mortgage payments, and you transfer it to your own revocable trust, it's okay. Otherwise, you're gonna have to get a consent from the bank to get it done.
Thank you.
So Steven, that will also apply if the foreign buyer buys under the personal name and then they want to transfer it to their LLC.
Yep,
So it'll be the same clause.
it would be the same clause, yeah. There, it's a little bit harder with the mortgages because if it's a trust, technically you own the trust, you're the beneficiary of the
Right.
trust, so it's not seen as drastic of a change. But if you're creating a company and you're transferring title to someone else, that company is different from the individual. So usually the banks don't like that.
Unless you're pretty much 90% the owner of the LLC.
Whether you're 90%, 100%, or 1%, it's the same thing. The way the bank looks at it is it's a change in legal
Title.
ownership. But remember, like I said, now the real world answer, you pay your mortgage, your taxes, all that, you're gonna be fine.
Thank you, Stephen. This is Joanna. A quick question. How about for a U.S. citizen to purchase a property outside of the U.S.? Any advice on I mean, on how to structure that?
So, I mean, I would definitely buy under some sort of entity. Now, in terms of like saving on taxes, as US citizens, we don't get a lot of like breaks on income tax because like I said, we're taxed on a worldwide income. So whether we own it through an offshore, let's say we create some like Swiss, entity, everyone, thinks like, Swiss accounts and all that, it's secretive. It is, but the best way for me to describe like our tax system in the US is it's like the biggest honor code of life. It's up to you to disclose what you have and pay what you have. Now, if you get caught, that's a different story. But just because a US citizen creates an offshore entity, that doesn't prevent them from paying taxes or absolving them from their tax obligations.
Okay, so if I understood correctly, so let's say there's a client, US citizen buying in Panama, and they don't pay state taxes, then should they buy under an entity or
If they don't pay estate taxes over there, and you could create a Panamanian entity, um, and you won't have to pay any taxes in Panama, but you're still going to pay taxes in the United States.
got it? Thank you so much.
You got it.
Stephen, as far as the 1031 exchange, because you said that, we're not exempt of paying taxes. However, if we do hold investment properties under a 1031 exchange, is there a minimum number of years that the property you have to be the owner before you put it in the exchange?
So basically, if you're doing an exchange, whether you're a U.S. citizen or a foreign person, you have to hold on to the property for at least a year and a day. So you could basically do an exchange like every other year and defer taxes.
Okay, and if someone is holding title under a trust, would that be considered an investment property to them?
Yeah, as long as
If
so
you,
so the only thing that makes a property investment versus not an investment is whether or not you rent the property, right? Like if you own the property for a year and you have a tenant, or let's say you're building something and you're gonna sell it, that's considered investment purposes. But
right,
the people that are not considered investors are like the fix and flip guys. So the people that
right.
buy properties on the courthouse steps, they
Mhm.
rehab it real quick and then 6 months later they flip it. The 1031 doesn't apply to them. So you have to be an investor, not a dealer. So that's the distinction the IRS makes for those individuals.
Right. So even though you own a property under a trust, as long as the property has been considered or been rented for a year, you can apply for the 1031 exchange.
Yeah.
Okay, that's
Or, I mean,
great.
you don't necessarily have to rent it. I mean, as long as you've held on to it for a year, like, because for instance, let's say you have vacant land, like, you can't really rent out vacant land to anybody. I
Right.
mean, maybe you could lease it to AT&T and they build like a cell phone tower on there or something. But other than that, there isn't really like, the ability to rent vacant
For
land. So as
renting
long as
it.
you hold it at least a year, then you'll be okay. A year and a day, you'll be okay.
And that's a national law that applies to any state. Like if you
Applies to
sell
all
a
states.
property like in California and you want to do that as an exchange to buy something in Florida, that's considered a national law?
Yeah, you can. California's a little funky. They don't defer the state taxes there, but federal taxes, yeah. So what you owe to the IRS, absolutely. So I could sell in New York, buy in Florida, sell in Florida, buy in Wyoming. It's worldwide. But if you sell foreign, you have to buy foreign. So if you sell domestic, you buy domestic. If you sell
You buy
foreign, you buy
domestic.
foreign.
Got it.
Because for
Got
whatever
it.
reason, the IRS doesn't consider property outside the US like kind to property in the US, even though
Mhm.
it's dirt, right? It's just in a different
Right.
location.
Great. Great. Any other questions that you might have? Anybody in the chat? Thank you, Carolina, Johanna, for your participation. Anything else?
No, thank you guys.
And also affiliated, Stephen, you also do closings, correct? Just regular closings. You have a full,
Yes, not me personally, but my
yeah,
partners or
you're
some of
right.
my
Yeah, but
partners
under the umbrella of affiliated,
of
you not
affiliated.
only
Yeah.
do international, but you do also regular closings here.
Yep,
Thank you very
Perfect.
much.
you got it. Hopefully,
Thank
this
you.
wasn't too painful for you guys.
Well, it's a deep subject. It's not many people deal with international clients. And as you couldn't have said it better, do not give any advice. to our clients. This is our classes are to be informative so we can learn more about all these topics and just know who to address it to. That's the importance of the club, that if you have a client that might be in this circumstance or this situation, we know that we can always go to our trusted partners and vendors who will take care of our clients in the proper way. But at least our realtors who deal with this are available to find all the answers with you guys. So thank you so very much, Stephen. And Affiliated has been our one of our vendors since the beginning, and we're so thankful to have you.
Anytime, anything you guys need, just let me know.
Yes, I will program one for next year so they can get in class, in person, the CE credits.
Yeah, you got it.
All right. Thank you, Stephen. Thank you, everyone. See you next Wednesday.
Bye. Take care.
Bye bye. Bye bye.